The next thing I'd like to go over is trademarks. Trademarks are different from patents in that with patents you've got utility patents to protect how something works, you've got design patents to protect how something looks. With a trademark you're really not trying to protect an invention, you're trying to protect a name or a logo or anything that symbolizes the company that's selling the goods. And so the goal of trademark law is to protect the consumers from being confused. So when you get a rejection under trademark law, it's usually a rejection based upon potential consumer confusion. So with a trademark you can protect anything that is readily identifiable with your company if you're the one that happens to be selling it. So you can try to protect the name of your company, the name of the product, you can try to protect a slogan, a logo, a tagline, things like colors that you wouldn't think could be trademarked, but in some cases they have been. So let's look along that spreadsheet you have at the facts and features of trademarks. You can see they're relatively inexpensive if you pick a good and easily trademarked name, which is something that's going to be very distinctive, not generic, not descriptive of the goods. But if you pick a good name and do a trademark search, odds are you're start to finish under $2,000 for your trademark application. Like design patents, they're examined usually, within a year of when you file. Trademarks right now, they seem to be going about 4 to 5 months after submission. And with trademarks, the success rate varies dramatically depending upon whether you pick a good name, that is one that's really distinctive and unique, or whether you pick a name that is so descriptive of your goods that they can't possibly issue you the trademark on it. We'll talk a little bit more about what makes a good trademark name later on. But trademarks, unlike patents, can be extended infinitely, which is actually good because if you take a lot of time to build up a brand name or a product name, it's good you don't lose it after 10 years. So it's actually an encouragement for businesses to take some pride in their products and turn out a good quality product. And indeed, the entire advertising business would fade up pretty quickly if trademarks weren't extendable. So we've got some trademarks like Ford Motor Company that have been around for over 150 years. We've got others like Microsoft and Apple that'll probably be around 100 years from now. And so trademarks can be extended. After you get a trademark, you have to file what's called a maintenance or renewal fee at year 5. And then every year between years 9 and 10, after it's issued, you need to file. Now fortunately, you need to file a maintenance or renewal fee. Now fortunately, these fees are not much, so it doesn't take a whole lot to keep your trademark alive. But if you don't use your trademark or you abuse your trademark, you can actually lose your trademark. I didn't mean to make that a rhyme, but it kind of turned out that way. So anyway, trademarks are very good for protecting your brand, protecting the name of your product. They don't protect the item in itself, so don't think you're going to get any protection on the way a product works by trademarking it. Also, for our small inventors and our mom and pop, sometimes you don't need a trademark. If your entire goal is to come up with an invention, get a prototype, put a provisional patent on it, and then sell the entire thing, if you sell it to a large company, odds are they're going to have a marketing and promotions department and advertising departments whose whole job it is to do studies of what kind of name, what kind of colors go into the packaging, what kind of advertising campaigns that they should mount to try to sell this product. So they may not be terribly interested in your name. So unless you have a really cool name, if you're planning on just licensing out your invention, probably should not spend your money on a trademark, but instead put it into a better quality prototype, or perhaps that airfare to travel to the headquarters of the company that you're trying to license. So what makes for a good trademark? Well, the more distinctive you can make it, the more fanciful you can make it, the better a trademark. So something like Xerox, X-E-R-O-X. What does X-E-R-O-X have to do with photocopy machines? Absolutely nothing. What's a Nike? What's a Reebok? I don't know. I've never heard Reebok being equated with shoes until the company Reebok came out with a line of sports shoes. So the more fanciful that you can make the name, the less related to what you're selling, the better and the easier a trademark you're going to get. The flip side of that is that if you make it generic, you're probably not going to get a trademark, or even if you do get a trademark, it's probably going to be a very, very weak trademark. So if Reebok, instead of calling themselves Reebok, had called themselves tennis shoes, that's a rejection. They're going to get a merely generic, merely descriptive rejection from the U.S. Patent and Trademark Office. They're probably not going to get a trademark on that because it wouldn't be fair to let them trademark the name tennis shoes when tennis shoes just describes the type of shoe that people use for tennis and for walking around the town. So the more fanciful, the more unique you can make your name, the better chance you have of getting a cheap and powerful trademark. The more descriptive you make your name, either describing the goods or describing the town where they're made or describing the name of the person who makes them, the less likely you are to get a strong trademark. Next thing we're going to go over is copyrights. Now, a patent protects an invention to the point where you can protect with a utility patent either the way an invention works or with a design patent the way an invention looks. The goal of trademarks is to protect the consumer from being confused to the point where the consumer knows exactly what the source of goods is if they happen to be buying some goods or what the source of services are if they happen to be buying services. The goal of trademark law is to protect artistic creations. Now, a lot of inventors, the minute they hear copyright, they just say, you know something, I don't need to know about this, copyright just deals with artists, right? Well, it does deal with artists, it also deals with inventors. So if you're an artist, yes, a copyright is a wonderful way to protect your collection of photographs, the movie you just made, the song you just wrote. But if you're an inventor, copyright can be one of your most valuable tools, because with a copyright you can protect your website. Now, when I first started teaching classes about 10 years ago, a lot of people didn't have websites. Email, most people could use email, but it really wasn't as big as it is now. Today, you know, we're in 2012. Right now, you need a website. If you are going to succeed in business, you've got to have a website. You've got to be able to use email. So protecting your website is very, very important, much more important than it was 10 or 15 years ago. Unfortunately, people are ripping off websites like never before, and very frequently you'll find that a competitor will copy and paste entire sections of your website onto their website, or they'll steal pictures or things like that. So a copyright is a good way to protect that. So for inventors, a copyright can protect your website. It can also protect your packaging. It's amazing how many times, especially if you have your packaging done overseas, somebody will take your packaging and appropriate it for themselves, or a close facsimile thereof. So it can protect your packaging. It can also protect any trade show materials, any marketing materials, basically anything that you come up with to try to advertise or promote yourself, you can also protect with a copyright. Now, copyrights are the cheapest form of intellectual property out there. If you go to a law firm, they'll usually charge you $300 or $400 to get a copyright done start to finish. Copyrights are good for the life of the author plus 70 years. And so I know the things that I've copyrighted anyway, I know that I'm not the next Shakespeare or Stephen King. The stuff that I do probably is not going to have much of a value beyond my death, so I'm not terribly concerned whether it's life of the author or life of the author plus 70 years. But if you happen to be Stephen King or John Grisham or Clive Cussler, you're seriously concerned about how long your copyright is good for, because it's going to probably have some value to you 70 years after you're dead. Now, if you want to follow the key individual who is probably most telling in terms of the direction of copyright is Mickey Mouse. And if you want to find out more about how copyright laws get extended, just type into Google Mickey Mouse copyright law and you'll probably find out a lot more than you can find out in this short video. But suffice to say, the length of a time after an author's death for which a copyright is valid changes from time to time, and it may be changing again soon. So copyrights, a couple $100. Usually get them back 4 months, 5 months after they're filed. They're good for the life of the author plus 70 years, at least at the time of this shooting. And they can protect any artistic creation that you created or that you hired someone to create for you. And for inventors, again, it's your website, your packaging, any trade show materials. You can even trademark your user's manual if you want to. I mean, it's surprising how many people will not use your name. They'll try to avoid your patent, but they'll copy and paste your user's manual because they figure it's all fairly generic. So anyway, copyrights, if you're an inventor, don't forget them. They can come in handy. The other reason why you want to keep copyright protection going is that Under a theory called statutory damages, if you sue someone for infringing your copyright, you can ask for $150,000 for a knowing and willful copyright infringement. Now, court decisions have held that a knowing and willful copyright infringement basically means Control-C, Control-V. If they copied it from your site, it was knowing and willful. So it makes for a great negotiating stance if you can start off at 150 and say, okay, try to talk me down, rather than you start it under common copyright law, where you have to say, well, I think I can prove my damages, and I think I can prove your unjust profit, but I'm going to need to do a lot of discovery to get there. So it's very nice to start off saying, well, I think we can start at $150,000 per copyright infringement, and then we can talk down a little bit lower in terms of settling a case. So again, copyrights, very good for inventors to use in terms of trade show materials, owner's manuals, websites, packaging, things like that. Anything you create relating to your invention, you should consider copywriting.